is her pedigree is incredible. She's former CIA, former FBI special agent. I didn't have the honor to work with her when she was in the office, but I'm so honored to work with her now at News Nation. She's a News Nation national security and law enforcement analyst. So Tracy, tell us a little bit about yourself, and I'll tell the viewers about me a little bit, and we'll go into today's topics.
Well, I'm really excited to be here today, especially with you, Sarah. You're just such a wealth of legal information, particularly from the defense perspective. So I think it's going to be really helpful, to hear what you have to say, really about what happened today. And like Sarah said, I'm Tracy Walder. I was a CIA officer and a special agent with the FBI, and now I'm actually an adjunct professor of criminal justice at TCU in Texas. So I'm really looking forward to hearing what everyone has to say today. So I'm going to kick it back to you, Sarah.
Yeah, so I think that I was really prepared, Tracy, to talk to you and the viewers about the gag order, the discovery, the motion to compel the discovery, and the gag order and the motion to compel discovery, and generally the discovery issues, have now been scheduled for two different dates in June. I believe June 9th is the gag order hearing. The judge sort of indicated that the media was really looking at this from a one-sided lens. And I don't think it's going to get lifted based on what I saw, but I think it'll get modified. But we'll see. I mean, we could talk about those once they happen. They didn't happen today. But there sure as heck was a lot going on with that arraignment that was really uneventful. People were disappointed, I think, because they wanted to hear a not guilty. And, they wanted to hear his voice. And instead, he stood mute, right? A lot of the questions that I saw on our Twitter feeds, yours and mine, and then also just in DM and from the News Nation viewers, was about what this means. What is the legal significance? So I'm going to say what I think, and I'm going to turn it over to you, Tracy. But standing mute is obviously a right that the defendant has. Typically, at an arraignment, a defendant pleads guilty or not guilty, although a guilty plea is rare because, as you would agree probably, Tracy, once you plead guilty, you're done. I mean, essentially, yeah, you're convicted. You're pleading to
nowhere to go.
Right. So it's a not guilty, and that's what we all expected today.
Yeah.
Now, by standing mute, there is no legal, in other words, there's no written legal advantage that by standing mute, you're going to get something or you're not going to get the death penalty or whatever. As it stands, Idaho is a death penalty state. The state has not sought death penalty, although they certainly can. We're still in the middle of discovery. The defense still doesn't have everything to mount a defense.
From today, right? To start to notify him if they're going to seek the death penalty.
Correct. And so this is strategy. We saw this happen with the Parkland shooter, Nicholas Cruz. This is strategy. So number one, you've got 4 victims. I believe Gonsalves's father was on Banfield the other night saying, I'm going to be there and I'm going to wait for him to say guilty. Or, they're all obviously, they want to get the killer of their innocent, children, right, that were murdered and stabbed. So in a case like that, it brings the temperature down by not looking like a complete a-hole and saying not guilty, okay? And he's showing some form of remorse by silence by not saying not guilty in the event that he does take a guilty plea if it's in exchange for, let's say, taking the death penalty off the table. So there was absolute strategy in why he did that. And by the way, the judge and the prosecutor were not surprised that he did that. So the players were telegraphed ahead of time. They knew what was coming. And so when I hear people say, oh, there is absolutely no advantage. No, there is an advantage. There's an absolute advantage, and I think it was smart of him to do that. I didn't expect it. I expected him to show up and say not guilty. What do you think, Tracy?
So I think I expected him to, show up and say not guilty. I don't think anyone's surprised by that. I completely agree with you.
Right.
And I understand, I guess, obviously I am fortunate not to have been the victim, right, of a heinous crime like this. And so I understand why the victims' families wanted to hear those words. I get that, just thinking about their perspective. Mm-hmm. However, part of me wonders too, if this is part of a bigger bargaining chip for him, because really the only thing, I'm not an attorney, but the only thing that I can see that he has to, I guess, bargain with would be the death penalty.
Right.
And so, you know, in the case of Nicholas Cruz, you know, he initially pled not guilty. That's the Parkland shooter. And then he changed, he stood mute and changed his plea then to guilty later. And as a result, the death penalty was taken off the table. And so, again, I am just hypothesizing here. I have absolutely no idea. But part of me wonders if this is also, yes, it's his right to absolutely do this, but part of me does wonder if this is strategy on his side to avoid the death penalty. Now, do I think that that's going to happen? I truly don't know the answer to that, because we don't know the evidence, right? That they have. But, you know, I'm guessing the evidence they have is more than what was just in the probable cause affidavit. It has to be. Of course. And so, you know, I think part of it really was a bargaining chip as well. I'm not in the defense attorney's head, but that's kind of what I was thinking.
I mean, I think, look, if I was his defense lawyer and I still didn't have everything, all the evidence that is still being, whatever, they're claiming they're processing it, they haven't gotten around to whatever it is. But if I don't have everything and I can't really get a full picture of what's stacked up against my client in order to then know what the defense will be, in order to then know how viable that defense would be, I want to leave all the doors open. And I think that's what happened today, is that he came in and his lawyer was like, look, let's not look like, I mean, all eyes are on you. The entire nation's looking at you. These families, it's not one victim, it's four, right? To come here and say not guilty when you might, in fact, at some point plead guilty, let's just stay quiet. You know, let's just stay quiet. Let's just make that decision down. And I think it's really important. You know, we say silence is golden. And I always say that, you know, as defense attorneys, we got to know when to shut up. But it also applies to exercising that silence for our clients, you know. And it's not just about his Fifth Amendment, right? Because literally all he would say was guilty or not guilty. It's not like he would have to narrate, you know, what happened that night or where he was or tell the story. So it's really not a Fifth Amendment issue, but it's more about strategy, like you said, and leaving the door open so that if this is a really bad case in terms of irrefutable evidence, and he does in fact ultimately plead guilty in exchange for the death penalty to come off or whatnot, that he's not now pissed off for hurting, reeling families, you know, for nothing, I guess. So anyway, do viewers have any questions about the arraignment today so that we could answer those before we move on to the Dateline masterpiece?
I'm looking at some of the comments. So it looks like, if he's indeed indicted, will they go after his dad, do you think, for aiding and abetting?
It really depends on the dad's role. Driving with him, he was the driver, the dad was in the passenger seat. I said that from the very beginning. You know, he's a college guy, he's not a young kid, and he's independent, he's left the nest, right? And fathers and parents cherish the opportunity to spend time with their son, driving them back from college or, you know, for the holidays or whatnot. I did not see the dad being in the car as aiding and abetting. We certainly would need to have a lot more evidence to say that he knew that Bryan was the murderer of the Idaho 4, and then he went to like pick him up and bring him to Pennsylvania to avoid justice. I mean, that's a huge leap, and I don't see any evidence of it.
Well, and I agree, because especially, I guess, you know, with the Nightline or the Dateline, excuse me, show, you know, they were talking about how the sister had these suspicions. Well, here's the thing, they're just that. They're just suspicions.
Right.
His behavior was weird. I really don't know. I wasn't there. But, you know, like, I'm a parent. I would want to drive back with my daughter across the country.
Right.
You know, I don't know. Do I think his father and family members may have had an idea? They may have when more information started coming out, but that doesn't necessarily mean that they were aiding and abetting. And that they had knowledge of precisely what the crime was.
And, so and Tracy, it's not even enough if the stuff on Dateline was true about the sister suspecting him and then telling the parents, who then were
that's not aiding and abetting. That's just having suspicion.
Right. That's just having suspicion. So, by the way, even if that's true, he would have had to take some overt steps to to actually aid and abet. So
like destroying evidence and, like that's aiding and abetting, taking evidence and burning it in a burn pit, behind your yard.
buying the latex gloves for him to wear so that so his fingerprints are not all over the garbage bags or whatever, I mean, he went back.
History of text messages of him, telling Bryan that he was going to come pick him up at school so that he wouldn't be, suspected, even though he knew he suspected that he was like that. That would be aiding and abetting.
Yeah.
I don't think
you know what? We have a question from a YouTube viewer, Shannon, saying if we believe the silence was just a strategy by the defense. Yeah. That's what we just said, that it was strategy to leave the door open in the event that he ends up pleading guilty, that he's not changing the plea, that it's his first and only plea.
Right. And that's what I thought initially. But like I said, and again, I'm just really talking off the cuff here, it feels gross if you're a victim, right?
Yeah.
Like that feels gross to hear someone not utter the words guilty or not guilty. And so I get where that outrage is coming from.
Right.
But again, this is a legal proceeding, right? And this is a crime where evidence is being gathered and processed. And this is just unfortunately how it goes. But it's really sad for the victims' families, I think.
Yeah. So if viewers don't have any more questions on the arraignment today,
so someone does have a question about the dateline, it looks like, next.
About the arraignment?
No, someone has a question about Dateline.
Okay. So let's get into the Dateline stuff because frankly, I mean, the next thing that's going to happen in the courtroom is the discovery. That's big because if the gag order is modified, maybe we will know some of this evidence that ultimately gets produced. But I want to start with making some points about the Dateline. I took notes because I don't want to forget, and then I want to hear from Tracy and then the viewers. Give me 1 second. Okay. So the defense always comes in with context. I found the Dateline thing to be very speculative. In fact, it was based on an assumption that Bryan Kohberger is a serial killer. And then it went backwards to try to profile him as such. And then in that lens, trying to take everything that he's done or hasn't done to fit that profile. But remember, that profile was the assumption that this show was based on. And that's sort of, what was really clear to me. So a couple things that I wanted to note as a defense attorney is that we bring in the context, right? So his online statements from 15 years ago. All right, well, so what? I mean, maybe there are other statements that he's made that will make that normal. How many other cars that he drove in and out of the neighborhood connected to Wi-Fi? Where else did he drive that night? Did he make any stops? The fact that he would have had the knife because the sheath was left behind, but then there were no stops to dispose. I mean, they followed this Elantra, but he didn't stop anywhere. That's at least not something that we're aware of. How many teachers were going easy on grades after the murders? I mean, these people have been traumatized. I don't think it's unusual that teachers are kind in their grading right after this, tragedy in the community. But of course, Bryan Kohberger's because he killed them. That's why he's being kind in his grading. How many criminal justice students applied to the Pullman PD for a job? I mean, they're making that sound like it's because of his intent to kill. And it may not be. It may be completely normal for someone in his major. Had his teacher approved his research study or questions? I mean, what does that mean? I don't know. So I want to just put that out there and then let Tracy come in with her points and then we'll continue.
Sure. Well, actually, you know what, Sarah, let me go to the one about the research study first, because I've been following this case really since it started. And that was one of the first things. I am a professor of criminal justice, and this is what we do. And these studies, now, look, obviously, if we take his study in the context of what has happened now, creepy, right? No one doubts that in any way. We all have feelings and emotions, and that's normal. However, your professor has to approve your study, period, the end. Like that's the way it works. And so his study, if you just take it in the context of what it is, which is most likely his IRB approved master's candidate thesis, what they all have to do, was approved. It was approved by that school. It was approved. So I don't view it as suspect. Yes, again, the context disturbing, but I don't view it as suspect. the biggest issue that I saw, and I don't know if this is maybe because my career has been in handling
I
sources.
have a biggest issue too. I wonder if it's the same.
My career has been in handling sources and assets. That's
Okay.
what I did. Obviously, I worked them overseas, right? Like, and so you have backup to that information. You don't just take what a source says at face value. And part of the issue that I saw, particularly in the Dateline, they kept saying a source said, a source said, a source said, and there's no information whatsoever to back up that information. And I am someone that's very fact-based. Again, at the FBI, that's how you build a case against someone. And so that was really bothering me. And particularly when they were talking about that female teacher who asked him for help, I guess in putting in a camera.
Yeah.
Was maybe surveilling her. Here's the thing. Again, I try not to estimate, but if we think about it, everything about Bryan Kohberger that we now know that has come from the school was that he was a problem with other female instructors and with female students. So why would a female ask him for assistance? It doesn't make sense. And so I think the biggest issue I had was that we have a responsibility in sourcing to make sure that those sources are truthful and that that information is backed up by multiple points of origin and not just one.
Right, especially in a high profile case where both sides have an interest in a fair trial for the defendant, because the prosecution doesn't want any appellate issues, the defense wants a fair trial. So I thought you were talking about the most problematic thing for you from the Dateline, which I totally agree. I mean, if I saw a source said in my reports, discover, I'd be like, wait, what source? Like, how did you vet the source? Yes. I also I think those, like, whatever the things that were covered by the Dateline piece and what they called revelations or whatnot, none of it really for me stood out, was anything extraordinary. But the most problematic thing in this case, in terms of evidence, Tracy, for me, is that his phone was in airplane mode during the window of the murders. That is not a good thing. And I remember, I think I was on Cuomo or one other show, and I said, I mean, is this guy a rookie? I mean, if he's really a PhD student in criminology and knows all this stuff, and he's such a, pro serial killer, would you not take your own phone and maybe take a burner phone? I mean, most criminals take a burner phone. And so I've had an issue with this from the beginning. And so I also know that triangulation occurs between cell towers. I had a guy that was 30 miles away. I was able to prove that, and his phone was being pinged. So I know that those are not the most accurate forensics in cases like this. But the fact that his phone was off is something that is, I mean, that is problematic. It's not just about where he is based on pinging, but it's the fact that his phone is completely in airplane mode. That to me really is a problematic piece of evidence. And so I'd be curious to know what the defense is going to do more with that. But there was other things like the genetic genealogy. It's a new science. The defense has to review it.
That's what I've always felt about the knife sheath. Again, I'm not a defense attorney, but I think I've mentioned before, FBI, we always try to think like how the defense might think about a piece of evidence. That's just being smart, right? And so the knife sheath, in my opinion, that genetic genealogy, it is fantastic, and it has done some really great things, but it is a new science. And so
but it's also what led law enforcement to him initially. So it is as sort of, not to diss it, but it's still kind of new science, etc. It is what sort of opened Pandora's box. So for them to pursue leads on him. So it is an important piece of evidence. And I don't know how much of it has been, the prosecution's fighting, producing it, saying we're not using it. We decided not to use it. You're not entitled to it. And I think it's probably because of privacy issues, and the company that did the testing is sort of putting their foot down, not wanting the information out there. I don't know. But it is an important piece of information because it's what law enforcement, what led law enforcement to further investigate. All Are there any questions about the Dateline thing? Oh yeah, hold on.
I'm looking through the.
Debbie asks, how many times was he red flagged at the school? I don't know, but there was a big focus on the school because it was about how he treated female students. You know, his subordination issues with female authorities in the school. I mean, it was always his school problems always related to a female, from my understanding. And I think in this case, even one time is bad enough. It's like anything that he does is, out of context and yet significant to support that he is a serial killer, that even the decision to pursue criminology studies, are based on that goal in life of his, of being a serial killer. I mean, anything he does. And that's one of the things I had a problem with today with the standing mute, was that I was going on Twitter saying, no matter what he did, you would be interpreting it as predatory, as monstrous, as serial killerish. I mean, he's damned. I mean, there's nothing that he could do or not do that is not going to get interpreted and profiled. But I don't know how many times. I just think once is bad enough. I mean, that they're trying to make it look like he's an incel, that he had it out for these girls because he was rejected. And so anything that fits that narrative is fodder.
And look, he may have been those things. We don't know. We don't have access to all of that evidence. And, the thing is, yeah, it's bad that he was flagged for doing something like that. But the problem is just because you engaged in that behavior, which is really bad behavior, we both agree on that. And just because you're majoring in criminal justice doesn't make you into a killer, right? And so we can't then go assume that like all of my students.
I was just going to say, you're teaching a bunch of serial killers
this behavior. And I think, again, look, do I think there may be something more to the fact as why he wanted to study criminal justice? Probably. But again, we have to take those things. I doubt the prosecution will use any of that information, in terms of building their case, because I just don't see it as something that they need, quite frankly.
They would lose credibility.
Yeah, I don't see them using that to build their case. It's fodder and it's disturbing to talk about. But again, I just don't see it being used.
Honestly, that is fodder for a documentary on Bryan Kohberger after he's convicted, as going down as a serial killer in American history. No, seriously. Then let's talk about it. Let's dissect every little thing that he does and then put it, fit it into the bigger narrative. But right now, like I said, I think Dateline just started with the assumption and told all of the experts on there to go with that assumption that this guy is a predator and a serial killer and all that, and the conversation just revolved around that theme. The narrative to me seemed manufactured. Like, these were adorable girls. He was a loner. He was tormented by female rejection, which then turned into this plan to control and then to kill them. I mean, that was sort of, it was almost like it controlled everybody's narrative. Even the experts on this Dateline. Then there was like the circular reasoning that bothered me. Most things are not problematic facts unless like we assume that he's a stalker or serial killer. We have to assume he is those things for us to then take issue or feel suspicious about certain pieces of evidence or facts that come out. And that's not true of all of his pre-crime facts that Dateline brought out. So if he'd written, I took notes on this, if he'd written about hating women, if he had abused women, if he had stalked someone in the past, if he had been arrested for nuisance crime, right. I mean, those are like nothing burgers unless you assume that he is a serial killer and a stalker. Right?
There's another good question here. That it says, is he waiting to see what the prosecution will provide his team in regards to exculpatory evidence requests and hearing on evidentiary stuff before he makes his plea? I think he is, but
absolutely
correct me.
I think listen, when look, clients come in and they're guilty of sin, and I tell them, and the goal is to get the best deal as soon as possible, right? Not waste the state's time and just do the best we can. This is a very circumstantial case. There's a lot of dots and a lot of evidence. How much of it will withstand a challenge at trial remains to be seen. The defense cannot make that assessment truthfully until they have everything from the state. Everything the state's going to present at trial needs to be independently evaluated to the extent it's forensic and it's science. The defense needs experts. They need to go through expert independent testing and analysis. So you can't really, on a 4 quadruple stabbing homicide, you can't just tell your client, hey, plead guilty to everything, never see the light of day, without really knowing what he's facing and what it would look like at trial. So I absolutely think the right thing to do is to get everything, get a full picture, make that decision from an informed place, and then hope that by not going in there and saying not guilty in front of 4 families, that he's actually going to be able to mitigate the death penalty. And if they seek it and they're able to like take it off the table, I'm not sure how much they're willing to do that with 4 victims.
There's another good question about the standing silence. Is that the defense is going for an overturned conviction, which they might be. I don't know, which is much easier to attain if the defendant never reciprocated during the plea phase. Like, so I think what the person's saying, if the person never pled guilty, right.
Would it be easier to overturn? Right. I mean, based on what? Because
it would depend, right? On
right, because overturning a conviction after a trial really is based on judicial error in the rulings, admission of evidence that should not have come in, prosecutorial misconduct, jury misconduct, and it has to be reversible error. It can't be harmless error, meaning that it can't be something that, even though true, would have still led to the same guilty verdict,
Right.
So I don't know, unless I'm misunderstanding the question, I don't know how the manner in which he handles his arraignment, whether it's guilty, not guilty, or silence, would dictate an appeal. Because ultimately, if he pleads guilty pursuant to a plea agreement, his chances on appeal are very slim, because he's made an informed decision to plead. I don't think with defense attorneys like Ann Taylor and the team that he has a claim for ineffective assistance of counsel.
I think that's where I felt like that question was maybe going is could he say that he had ineffective counsel, right? Could that be, which is where I think like Lori Vallow may be trying to go,
right.
In her case,
right.
But I don't see that here. But again, I am.
I don't see that either. I don't see that here.
Yeah.
I think the only I think the only thing that his plea today or silence today at the plea hearing speaks to or can influence is his plea negotiations, if he in fact sits down to negotiate a plea agreement.
Or if they sit down with him to negotiate.
Exactly.
Right.
Exactly.
No offense, I'm thinking like the prosecution side. We gotta want to play with you.
Right. If they are willing to discuss it.
Right. And they may not be willing to.
Right.
They may say, look, we have so much evidence. We are not taking death penalty off the table.
Correct.
Trial it is. Right. And this may not go to a trial. But someone did ask me, and I've been asked this question a couple of times before, so I will answer it here. It says, do I think that Bryan Kohberger thinks he's smarter than law enforcement because of his studies? Again, this has nothing to do with any evidence that I've gathered, right. But in my opinion, I do think so. I do think just because, if we look at, again, I cannot use this, in a trial or anything like that. But if I look at some of his past behaviors and his course of study, I do feel that he does think that he knows more. And I'd be very interested to see the role that he's playing within
his defense.
Yes.
Oh yeah, he would be the guy that would get on my last nerve.
Correct. And so this is a defendant who, in my opinion, is probably telling his defense counsel what to do. A lot of times people don't do that, right? They're like, tell me what I need to do, and
trying to control his defense. And those are the most difficult clients, because a client who trusts you fully and understands that even as a lawyer, you don't know when it's you. When it's you really got to relinquish control to your representative, right? To your attorney. And I almost prefer people that have no knowledge of the criminal justice system in any standing, in any respect, to somebody who has some, because they think they know, and they think, and the Bryan Kohberger's attitude also is one that I think, I mean, what a joke, right? I mean, if in fact he is guilty of this heinous crime, back to my point, I mean, you're that smart that you did not get a burner phone, boo? I mean, what's up with that? How
And you
smart
drove
are
your
you?
own car to the scene
Right.
of the crime.
I mean,
Put that out there too.
right. There are two questions somebody typed up, is that, will any more court documents be released before the trial? That will depend on this modification of the gag order.
Right.
So if it's like a motion, like with the motion to compel, things like that literally get posted on the court's website, those are obviously public. But evidence and things that reference witnesses and evidence, I don't think we'll see unless the gag order actually gets modified, which I think is being heard on June 7th or June 9th.
Right.
There's another question. Do we actually expect the trial to start in October? Nope. Do you think so, Tracy?
No, I don't.
I think if he pleads, maybe it'll happen this year. But again, depends on how quickly all this evidence comes in and how quickly the defense can do its own homework. But I think if he's going to go to trial, it's going to be well into 2024 or 5.
I'm thinking late summer, early fall of 2020.
Of 2024?
If it goes.
Yeah, if he does go to trial, yeah.
Right. That's a big, but that's I guess pie in the sky, but I don't know.
Yeah. All right, guys. So I think that's it for the questions. But Tracy and I are both on Twitter. If you want to, post your questions and tweet us or DM us, we'll definitely be available and do. I don't speculate, so I'm not going to go down that rabbit hole. But anything that I know, I will share.
Yeah, I'm happy to, help however I can. I don't really speculate either, which I know annoys some people, but is what it is.
All right, guys. Have a great afternoon. Bye, Tracy.
Bye,
Thank
everyone.
you, Tracy.
Bye, Sarah. Thank you.
Thank you.